This is Stephen A. Williams, President and founder of the CreditRepairShop.com. This is a continuation of the Portfolio Recovery Associates lawsuit that was filed by the Consumer Financial Protection Bureau. This is a real customer's, one of my clients' follow-up second notice to a debt collector who has not responded to a debt validation. I've blanked out the client's information, but you can use this information to make a letter responding to a debt collector that has not responded to your debt validation claim. So you can see here, RE, failure to respond to a debt validation pursuant to FDCPA section 809A, validation of debt, 15 USC 1692G. As required by the Fair Debt Collection Practices Act, I have a right to request a full debt validation for your claim. More than 30 days have passed, which it was actually a lot further. We gave more time. Since I've mailed you a written certified letter by U.S. mail stating my request to have your claim fully validated pursuant to FDC PA Section 809A 15 USC 1692G, which is your right to do a full debt validation. The reason why we use the word claim is because they're going to use that word in their, if they decide to take you to court and they're making a claim. Because you haven't responded to your debt claim, your debt claim is void. We're stating that it's void. We believe that it should be void. We don't want to give any open door. Let them come back with what they're going to respond with. You are required to cease all collection actions and remove any information you've placed on my credit reports. I look forward to your prompt reply. I further insist that if you have reported me to a credit reporting agency, you remove any information about this alleged debt. And then sincerely. And then we have here at the bottom, California State Attorney General's Office of Compliance and Department of Financial Protection and Innovation. Okay, now continuing on the Portfolio Recovery Associates lawsuit that had happened. I just showed you where the debt collector refused or they just didn't respond to a debt validation request. Look right here. Consumer disputed, challenged, or questioned the validity of accuracy of a debt, and respondent failed to review information that would have been necessary to have a reasonable basis to continue collecting on the debt. So we just showed where they get in trouble for not where I just showed you a letter where we're responding for a client, and here we have right here portfolio recovery agents associates had got sued by the Consumer Financial Protection Bureau for not responding. And then we have here respondent had knowledge or reason to believe based on the contractual terms or past performance of accounts sold by a seller that specific portfolio of accounts contain unreliable data. Unreliable data, I repeat it again. But respondent failed to obtain and review information that would have been necessary to have a reasonable basis to collect on the debt. So just like what we're going through with this client that we have, and this debt that they're trying to collect on is over $50,000. They have not responded. So could it be possible that the portfolios that they purchased the debt from had problems in them, and they're now refusing to do anything to check because they can't really check? My thinking is that they just don't have the information, and they want to see if the consumer is going to stop questioning, so they can just go and try to get a default judgment, which is what portfolio recovery was doing. As we go here on line 65, the representatives are material because they are likely to affect a consumer's choice or conduct regarding how to respond to an alleged outstanding debt, and are likely to mislead the consumers acting reasonably under the circumstances. So we have here misrepresenting that PRA intends to prove the debt if contested in violation of the CFPA, Consumer Financial Protection Act. So what they're saying here is that they're saying that if you try to make us prove, it's going to be worse for you. In numerous instances during the relevant period in connection with collecting or attempting to collect the debt from consumers through litigation or threats of litigation, uh, respondents represented directly or indirectly, expressly or by implicating that PRA intends to prove its claim if contested. So they're trying to say that if you ask for a validation, that we are going to furthermore prove that you owe rather than going by the law, which is if you ask for validation of the debt, that they just have to simply validate the debt. In truth and in fact, in numerous instances, respondent did not intend to prove its claim if contested. So that means that if you were to do a debt validation like what we did for this client here the first time, that they were not going to actually do a valid, like they wasn't going to follow up on it. So there, in which is required by the Fair Debt Collection Practices Act and required by the CFPB. These representations are material because they are likely to affect the consumer's choice or conduct regarding whether to pay the debt or contest the lawsuit, which is what we tell people to do regardless, and are likely to mislead the consumers acting reasonably under the circumstances. And we got filing misleading collection affidavits, which is something that I talk about in my videos, and what I've seen happen with debt collectors who file lawsuits. They have fake, I consider them fake affidavits. They are not from the original creditor. They are where they have someone from their company make the, sign and say, I've looked at the documents that were sent to us from the original creditor and I believe that they're true and 100% in line with the business practices of the original creditor, which they can't speak to that because they don't work for the original creditor. So you can see here they were filing false affidavits in violation of the CFPB. In numerous instances during the relevant period in connection with collecting or attempting to collect a debt from the consumer, and an affidavit filed in courts across the country, respondents represented directly or indirectly, expressly or implicated that PRA, Portfolio Recovery Associates, had a reviewed account level documents from the original creditor. They did not. Documents attached to affidavits were specifically to the consumer or PRA were familiar with the contents of account agreements, truth, and in fact, in numerous instances, PRA had reviewed account level documents. They never reviewed account level documents from the original creditor. They only reviewed the microfiche or the digital file from the original creditor. Let's see here. Misrepresentation regarding time-barred debt in violation of CFPV. In numerous instances during the relevant period in connection with collection or attempted to collect a debt that is beyond the applicable statute of limitations from consumers, respondents represented directly or indirectly, expressly or by implication that the consumer had a legal enforceable obligation to pay the debt. In truth and in fact, consumers do not have a legal enforceable obligation to pay a debt that is beyond the statute of limitation. I talk about that a lot. So that means that if a debt is past legal statute of limitation to collect, you do not have to even request a validation. You just have to notify them that you know that the debt is past the legal statute of limitation. They have no legal enforceable obligation for you to pay. Misrepresentation regarding attorney review. In numerous instances, I'm going real fast because they're just repeating a lot, but basically what they're saying is that, and we'll go down here to line 82, representation set forth in paragraph 79 are false or misleading, constitute deceptive or a deceptive act or practice in violation of section 1031A, 1036A of the Cfpv. What they're basically saying is that an attorney reviewed. An attorney did not review. In truth and in fact, an attorney had not reviewed the consumer's debt, and the collection was not calling on behalf of an attorney. The collector was not calling on behalf of an attorney, and an attorney had not reviewed the debt. They cannot take you to court without having an attorney review the debt because they're stating that the attorney did review the debt. Misrepresentation, imminent litigation. They cannot say that they're going to sue you for the debt without suing you for the debt. I know that this is a gray area, but if a debt collector said that they're going to sue you about a debt, give them 30 days. If they don't, you send them a letter stating that they have violated the Cfpv or the Fair Debt Collection Practices Act by threatening to sue you when they were not going to sue you.
Returning visitor.
This one here, we've already talked about. They use a dialing system. They can't use a dialing system to call you. All right, I'm going to end the video here because I think that this is enough for you to be able to move forward today, and we're going to make a part 3 on this video here. Basically, what it comes down to is that a debt collector cannot threaten to sue you if they're not going to sue you. Comes down to that they cannot make false affidavits saying that they reviewed the records of the original creditor because they don't have access to that. Number 2, they have to do a debt validation regardless. If they disregard it, you give them you can give them up to 30 days. Really, they're supposed to do it within 10 days. And they're supposed to notify within 5 days that they do got that it is being disputed.
Returning
If they
visitor.
disregard, you can send them a letter saying that you want the debt to be void because they're in violation of the Fair Debt Collection Practices Act. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, and you can see exactly how we repair credit. This is included with our services, going back and forth with debt validations to debt collectors and original creditors. If you need your credit reports and scores, visit us at www.your3scores.com. Links are below this video. If you need my cease and desist collection activities letter, statute of limitations letter, or debt validation letter, those letters are below here. Thank you for your time. This is Stephen A. Williams. Make sure that you subscribe to the channel. Make sure you ask your questions, comments, and thank you and have a great day.